Hello, everyone, and welcome to the launch of Wearing Blinders, How Development Banks Are Ignoring Reprisal Risks. On paper, most development banks are committed to respecting the rights of communities to be consulted and to participate in decision-making processes around projects that affect their lives. Yet, meaningful participation is just not possible when those that raise concerns about development activities are subjected to retaliation and face attacks simply for speaking out. Today, we're going to be discussing the failures of development banks to properly assess and address reprisal risks linked to their investments. My name is Hannah Story, and I lead the business and human rights advocacy at Frontline Defenders, and I'm going to be moderating today's discussion. First of all, we're going to be hearing from the report's author, Dalile Antunes, who will give us an outline of the report and the key findings. We'll then go to a panel discussion where we will hear powerful testimonies from human rights defenders Gerald Kankia from Uganda and Anna Shaknarazan from Armenia. We'll also hear from MEP Heidi Hautala and UN expert Anita Ramazastri about the importance of human rights due diligence and the practical steps that development banks should take to mitigate reprisal risk. I want to remind everyone that there is interpretation available today in French, Spanish, and Russian. So if the speakers could please keep to a slower speed, that would be fantastic. We'll also hopefully have space for a Q&A later in the session. So please do put your questions into the Zoom Q&A box or into the comments section on the Facebook Live. We will monitor the chat there. So now I'd like to go to Dalile. Dalile Antunes works as a collaborative researcher at the Coalition for Human Rights in Development and is based in Argentina. And she is the lead author on the Wearing Blinders report. Over to you, Dalile.
Thank you very much, Hannah. Very briefly, I'm going to explain the kind of analysis that we did in the report and share some of the key findings. In the report, we documented cases where DFIs have failed to assess, avoid, or mitigate the risk of retaliation faced by communities impacted by development projects. We selected 5 cases in different countries in which different kinds of retaliations happened to defenders after the approval of the projects. The reprisals include physical attacks, killing, criminalization of defenders, also civil lawsuits against public participation, smearing campaigns, among others. In some cases, the conflicts and the reprisals eventually led to the failure of the projects and to the withdrawal of the funding by the banks. In order to assess the failures in due diligence, we analyzed the project documents and we talked to defenders and members of the communities to answer mainly the following questions. Did the banks anticipate reprisal risks in the project documents? And how could the banks anticipate those risks? And what kinds of things happened prior to the approval of the project that revealed clearly the risk of retaliations and should have been considered by the banks during the appraisal stage? So our analysis of the different case studies allows us to draw the following main conclusions. There are more conclusions, but I'm highlighting just the key ones. In all of the cases, there was a failure to assess risk of reprisals. The project documents that are available don't reflect an analysis of those types of risks. There are other types of risks, but not reprisal risks. The banks also failed to assess specific gender-based risks, risks of reprisals that affect women in human rights offenders in a particular way. In all of the cases, retaliations could have been anticipated if banks had performed adequate due diligence. In some cases, the information that indicated risk of reprisals was known by the banks prior to the approval of the project because it was raised by defenders through complaints or at meetings with the banks, but the projects did not reflect an analysis of those risks. Also, evidence of serious restrictions to civic space and participation that was produced by UN human rights experts was also not taken into consideration by the banks, and the poor human rights track record of clients or implementing agencies was also not analyzed and taken into consideration in the project documents, even though it clearly signaled reprisal risk. The case studies also show that retaliations were also foreseeable if the banks had ensured meaningful participation, transparency, and stakeholder engagement, and free, prior, and informed consent of indigenous peoples. The lack of meaningful participation is one of the key elements that heightens reprisal risk in the cases documented. If projects are imposed without engaging people affected, the risk of social tensions increases. And the last finding I would like to highlight is that banks relied heavily on the clients to assess the different projects' risks and impacts, to identify and engage the affected communities, and to assess the results of consultations. And clients have a conflict of interest that prevents them from disclosing information that could risk the approval of the projects. These are the main findings that shows that despite the fact that DFIs have policies where they commit to respect the rights of communities to be consulted and participate in decision-making processes, they are ignoring risk of reprisals, and this leads to reprisal escalation. When risks are ignored and banks deny the responsibility, this exacerbates risks for human rights defenders and also jeopardizes the project expected outcomes. Thank you very much.
Thank you very much, Dalila, and I want to congratulate you on an excellent report, which I'm sure everyone will be reading following today's launch. It's really truly horrifying to hear that not only were these risks not being assessed, but when they were brought to the attention of the banks, they were being ignored. So we're now going to turn to our panel discussion. And first of all, we will be hearing from two human rights defenders whose cases appear in the Wearing Blinders report. So first of all, I'm going to turn to Gerald Kankia, who's a human rights defender from Uganda and the director of TLC Uganda. I'm going to give a very brief introduction to the case first, and then I'll turn to Gerald with the first question. So in 2021, the World Bank approved a conservation project in Uganda of $2.3 million, which was affecting 3 national parks. And this was approved without proper human rights due diligence. The project implementer, the Uganda Wildlife Authority, has a notoriously poor human rights track record, with its rangers being accused of attacking and killing indigenous community members living in areas around national parks, including around the Toro Semliki Wildlife Reserve, where Gerald has been working. According to data gathered by TLC, since 2015, the Uganda Wildlife Authority rangers have been responsible for more than 86 attacks, including at least 29 killings, and the retaliation against local human rights defenders is ongoing. So Gerald, it's truly shocking to hear that the World Bank has decided to fund the Uganda Wildlife Authority to implement a project despite this track record. Can you tell us exactly what has been the key due diligence failings of the World Bank around this project? Thanks.
Thank you, Hannah, and it's my privilege to also take part in this process. Start with the bank, while approving this project and up to the point of implementation, did not conduct any conducive necessary consultations with the communities that would be affected by the project. We find specific instances where communities were deliberately avoided because there was already an existing conflict. And under these circumstances, we could never have had any form of consultation because of the existing conflict. Back to the aspect of due diligence, and this is clearly evident that the bank never conducted any any due diligence. Otherwise, it could have detected that there was an existing court case where the entire communities had actually filed complaining to the high courts of Uganda about the various trends and patterns of human rights violations like killings, extortion, land grabbing, destruction of property. And all these, if the bank had conducted a thorough due diligence process, it could have easily been detected. Take an example, and this seems to be the same pattern, that this bank does not actually conduct a thorough due diligence process. Recently, before coming here, we discovered that the bank has actually approved another project that is affecting over 2,000 families who are already evicted, but the bank has gone ahead to approve this project. It's an evidence that due diligence is not a clear process within these bank processes. The other aspect that is very important is lack of third-party assessment. Whereas Uganda Wildlife Authority has been accused as a major perpetrator of human rights in these communities, the bank went ahead and trusted the Uganda Wildlife Authority to conduct consultation, stakeholder engagement, and further assessment within these communities before implementing an activity. No one would ever give a genuine, honest opinion of the existing situation when he or she is directly involved in a conflict. This is why we think there was a lot of gaps within the bank's position in taking due diligence as a key factor before approving this project. Thank you.
Thank you, Gerald. And a clear lack of human rights due diligence there. If there was a case at the High Court of Uganda and that wasn't even spotted, let alone, you know, not speaking directly with community members, that's just very egregious. So thank you very much for joining today and sharing that case. And I'll come back to you in a minute to share a little bit more details as well. But I want to turn now to Anna Shaknazian, a human rights defender from Armenia and a member of the Armenian Environmental Front, an organization which is leading the struggle against the notorious Amulsar gold mine. Again, I'm going to give a very short introduction, Anna, and then I'll turn to you with a question. So the Amulsar mine started being developed by Lydian International back in 2006. When it was funded by many different international investors and banks, including the International Finance Corporation and the European Bank for Reconstruction and Development. The mine has been met with strong opposition from the beginning due to its serious environmental, health, and economic impacts. Despite local communities raising their concerns repeatedly, the development banks involved, particularly around the lack of consultation, the project impacts, and the retaliation risks that activists were facing, the European Bank for Reconstruction and Development decided to go ahead with a second investment in the project in 2016. Protests against the mine also escalated in 2018, with community members blockading access to the mine. So Anna, I was hoping you could tell us how the company and local security forces reacted to these protests, and also tell us about some of the legal charges that human rights defenders in the communities have faced over the last few years.
Yes, thank you, Hannah, very much. And thank you to organizing the presentation of this report with our participation of people actively involved and firsthand involved in resistance to disastrous projects. Before I answer your question directly, because you have mentioned important development financing institutions, the World Bank and EBRD. The World Bank was first involved in its IFC arm, the corporation. What I want to say is that right now, we environmental defenders have been presented as dangerous disseminators of lies when it comes to development projects. Look at this, in a draft mining strategy that has been supported, is being supported by a World Bank grant, and the government with the World Bank support is drafting a new mining strategy, which will be even more detrimental to the country and to the development of the country, and of course to us. I just heard this, that this formulation is included there, and I'm just very alarmed. I heard this about exactly today. I haven't seen that draft, and very few people in our country have seen the draft that the World Bank is supporting through a consulting company that has involved the Amulsar's clients, many experts, people that have been denounced, and their allegations have been denounced by other world leading experts. And so they have been gathered together right now, drafting drafting a new mining strategy that will put forward new similar mining case projects similar to the Amulsar one. And Amulsar is not yet over. I mean, while we know that the company went bankrupt after these protests and after a lot of the resistance, and I will talk about the reprisals and the security forces in just a second, I want to say that this project is not really over. The company dissolved and restructured, but the permits and the licenses, and they're still held by, the new owners. And there's a big interest by the new government of Armenia to push this project forward, despite all the problems that have been mentioned, both in your report and in many other reports, but just another report that came out exactly today, earlier in the morning in Yerevan, we had a presentation of that report. So what I want to say is that, first of all, thank you for giving us the floor, because the development banks don't really recognize us as legitimate speakers. And I'm not mistaken on that assessment. But secondly, other than just raising this red flag that I mentioned about the new mining code mining strategy, being developed with the support of the World Bank and being so problematic already. Consultations is a word that is deserving a lot of attention. Consultations also means the securing of the right to say no. And so in the project that has been the case study for your report, the community's right to say no was not safeguarded. They said no to this project so many times. And what I want to highlight is that eventually their resistance and their no worked, and it worked against all the investors in this gold mine project. And I want to say that any new investors, despite all the pressure that we have faced, despite so many criminalizations, so many legal charges, civil suits against activists, against our group, against local community members, so many even suits against the government agencies themselves, despite all of these intimidations and pressures, there will continue to be serious resistance to this project. So what I want to say that this case study is just a manifestation how wrong the development banks were from the very start, because they were key investors. I mean, they had equity shares in this company, and they were lobbyists. They were really very strong proponents within, the investment world, financial world, and within the Armenian government, for the Armenian government as well. After the security forces were very brutal towards protests in 2019, some changes did happen, and EBRD was alerted. And I think, according to information I received, I haven't been in touch directly with EBRD. EBRD eventually took an action and contacted their client company, Lydian, and Lydian actually had to change their security company. But that does not mean that a lot of the local residents who were actively resisting, they don't face criminal charges. They still continue to face a lot of criminal charges because of the conflicts that arose from different provoked violent activities. Some of these provocations were definitely taken by the security guard company that Lydian had hired earlier, and then they had to change after, I believe, and that's really very much a hearsay, EBRD intervened, because we did raise this issue to EBRD. At the same time, the fight will have to continue if new investors show up. And despite all the cases of pressure and reprisals and other threats that are detailed in your report, there will be resistance. There will be we won't back down, basically. That's what I wanted to say. I'm sorry if I took a bit long.
Not at all, Anna, and thanks. Just You thanked us for giving you space, but thank you very much for joining and sharing this story. It's really important to hear what's going on, the reality, rather than, you know, sitting in the theory. So thank you for joining. I'm going to go to Anita Ramazastri next. Anita is an expert in the fields of business and human rights, anti-corruption, commercial law, and sustainable development. She currently serves as a member of the United Nations Working Group on Business and Human Rights, having been appointed in 2016. She is the Special Representative of the OSCE Chairperson in Office on Combating Corruption, and she is also a Professor of Law and the Director of the Sustainable International Development Graduate Programme at the University of Washington School of Law. Anita, in your expert opinion, why does human rights due diligence matter in the types of contexts that Anna and Gerald have just described here? And why should development banks integrate human rights due diligence into all of their projects?
Great. Thank you so much, Hannah, for this. My internet connection's a little unstable, so if I need to turn off my video, let me know. I want to congratulate the Coalition for Human Rights and Development and to thank Dalile, but also Gerald and Anna for bringing these issues to life and really speaking about them in a way that I hope development finance institutions will listen. The UN Working Group on Business and Human Rights, our work and our role is to work with stakeholders around the world on promoting the UN Guiding Principles on Business and Human Rights, which really focus on this idea that economic actors, so not just companies, but economic actors, will respect human rights and prevent harm. That's what the key message is today. As cited in the new report, Wearing Blinders, the working group very recently launched guidance on the UN Guiding Principles and respect for human rights defenders. And what we say in there is some key messages which are very, they are quite consistent with the recommendations in the Wearing Blinders report. So the first one, Hannah, as you mentioned, is just this key message that the guiding principles do apply to development finance institutions, that this is key. As economic actors, they have a responsibility to identify any of the harms that they are directly linked to and to take steps to prevent them. And this includes, most importantly, very specific risks to human rights defenders, including reprisals. And so the first question of, do the guiding principles apply? The answer is yes. Because development finance institutions are entities often controlled by the state or by governments, they have heightened responsibility under the first pillar, which is about the state duty to protect. And of course, states that are shareholders, right, also have responsibility to use their own leverage with these institutions to advocate for change. But what does that mean? Now, the working group over the past decade has visited countries around the world and country missions from Peru to Canada to Kenya to Thailand, all continental regions. What we have seen in all of our visits is that very often the risks to defenders arise in the context of development finance projects, very much what you see in the report today. So we have spoken to defenders and communities that are impacted on the ground in connection to development finance. What we hear repeatedly and what this report really calls for is the fact that meaningful consultation with defenders needs to begin at the beginning and continue to understand the risks that they face and to take steps to identify that. Too often we see there has not been that consultation, and that leads to conflict and to risk. The second piece is the steps of identifying what those risks are through due diligence, looking and saying, what are the risks in general to people from the project or activity, but what are the specific risks to defenders relating to their lives, relating to court proceedings against them. This is very important. And we have guidance from the High Commissioner's Office on Development Finance and Human Rights and from the working group. We receive communications and requests for help around the world from defenders, again, relating to development finance. So I think the evidence base is very clear, and if it is not, this report and hearing from Gerald and Anna is very clear on what are these human costs. So the last piece is reprisals in particular. Due diligence can help prevent harm, but if there is a threat to a defender, then development finance institutions need clear policies, but they need action. Behind the policy, steps to protect defenders, to raise issues with governments or security services or any actor or companies that may be linked to the harm. So this, I think, is the clear message of Waring. The report today is those next steps to move a policy into practice. Again, thank you for the opportunity to be here.
Thank you, Anita. Just to echo that last point, moving policy into action, I think is a really key message from today. Many of the development banks have made commitments and statements around addressing reprisals against human rights defenders, but how are they following that up? What is the action that they are taking? So I'm going to go to our final panelist now, to Heidi Hautala. So Heidi is a Finnish member of the European Parliament representing the Greens, and she is also Vice President of the European Parliament. This term, she serves as a member of the Committee on International Trade and of the Subcommittee on Human Rights. The main themes in her work are human rights, global justice, and environmentally responsible legislation. She is also the founder of the European Parliament Working Group for Responsible Business Conduct and has been one of the leading advocates for the new EU legislation on corporate due diligence. So Heidi, as Anita just mentioned, the shareholders of development banks have significant obligations under international law, and the European Union and the European Union member states are shareholders in all the major multilateral development banks. So in your opinion, what should the EU and member state role be in ensuring that development banks improve in the area of human rights due diligence?
Thank you, Hannah, and thank you everybody for bringing us together to discuss the conclusions and follow-up of this important report, Wearing Blinders. As Anita Ramasastry has so well said, there is the state duty to protect human rights in the UN Guiding Principles. So there's no way that the UN Guiding Principles would not apply to states being shareholders in development banks. It's just, I think that this whole discussion has very much now focused on purely private sector obligations on due diligence and responsible business conduct. But there is no way to escape the fact that the next in line will have to be the public sector. And I'm just referring to ongoing discussions on how public procurement should also apply principles on human rights and environmental due diligence, because there's no logic in asking the private sector to be responsible if the ones that are stipulating laws actually would somehow alleviate or run away from that obligation. So the same certainly is true of development banks. And of course, there has been quite some development, and how would I say, it's a long discussion between the civil society and the development banks, how to conduct environmental and human rights impact assessments. But until now, I see very little serious, I would say, implementation of those principles. But I would like to say that we have some good practices already. And I'd like to cite the example that many of you know very well from Honduras. You remember when Berta Cáceres was murdered. Berta Cáceres is a very well-known victim of reprisals and retaliation by let's say, state-related a company that wanted to build a hydropower project in the lands of indigenous peoples. And two development financing institutions were involved, the Finnish and the Dutch. And I remember having spent a whole afternoon with the management of the Finnish FinFund, asking where they think things started to go wrong, because it went so terribly wrong that the representatives of the Lenca indigenous people, Berta Cáceres above all, was killed because of her activism. And I do believe that this has been one root cause why they actually started to cooperate with the Shift project. For those who do not know Shift project, it is an organization that was built around the implementation of the UN guiding principles by the late Professor John Ruggie, who was clearly the founding father of the guiding principles, and who unfortunately died last year in September, just when things started to really move to the direction he was advocating for years. So the Shift project has been able to provide a Finnfund, the Finnish development financing institution, with very good advice on how to conduct human rights and environmental impact assessments. And there has now been an independent evaluation, and I'm happy to say that it seems that Finnfund has succeeded to some extent. So it is possible to change behavior, and I believe that one of the key issues here is that sometimes there is, let's say, quite a distant relationship with the financing institution, whether it could even be like a private finance operation by banks and those who implement the projects. And that has to change, because I think it's also a bit of a smokescreen that should not be between the financing institution and the entity that they are financing, the project they are financing. It is their duty. It is their duty of care. It is their duty to perform a proper, well-designed due diligence process. And here, of course, then we come to the issue of what we have started to call meaningful consultation, meaningful stakeholder interaction, because it's often very formal, it's very minimal, and it's just, a bit, I'm tired of saying tick the box exercise, but that's what it is often. And it should not be. It should be real, genuine interaction to learn and to develop ideas together with the affected stakeholders, respecting their rights and respecting international principles of customary law, such as the free, prior and informed consent, which surprisingly sometimes when we are discussing legislation in the European Union, there is no real commitment to this important principle, and that has to change as well. But so the companies and the financing institution should secure and assure a meaningful consultation and interaction with the stakeholders. And lastly, I would like to say that a very important issue that was already mentioned is what happens to human rights defenders. And the statistics are really grim, that by far the largest category of human rights defenders that are now risking their lives and even losing their lives are environmental land rights defenders. So a lot of attention should be directed to this. And that's, I believe, why, for instance, the UN Special Representative of Human Rights Defenders, Mary Lawler, is very active towards the EU to make sure that the EU Corporate Sustainability Due Diligence Directive will have a strong element of the obligation to protect human rights defenders. Maybe one more thing is that in the forthcoming European legislation, which of course could have a positive spillover effect far beyond EU's borders, affecting also the practices of development banks. It's very, let's say, minimalistic in terms of defining risk sectors, but mining and agribusiness is mentioned. And I believe that this reflects the fact that indeed land rights and threats to land use is unfortunately gaining importance, because the threats to people defending their lands are growing. And of course, our let's say, consumption patterns in the affluent countries are a key cause of all this. So it's key that we finally start to address the problem of our wasteful and dangerous consumption patterns. So thank you.
Thank you, Heidi. And I look forward in a minute. I'm going to ask you some more questions about the EU legislation. I think there's a lot of people here who'd be interested to hear some more detail. But actually really linking to what you were saying there about the lack of meaningful consultation being an issue, I want to come back to you, Gerald, because one of the things you mentioned is that the World Bank entrusted the Uganda Wildlife Authority to conduct the consultations despite this horrific human rights record that you've explained. Could you tell us a bit about how those consultations were conducted and what you think the bank should have done instead? And I will just remind speakers we're a little bit over time, so if we can keep our responses a little bit short, that would be great. Thanks, Gerald, over to you.
Thank you, Hannah. One of the things I need to make clear is that Uganda Wildlife Authority has a policy that in circumstances you have a court case against them, you don't talk to them, you have no consultations or whatever kind of discussions. So this should have been the first thing for the bank to have kind of detected, because until today, any person who is suing the authority for grabbing their land cannot be involved in any form of consultation. So all the people that were involved in the court case have never been involved in whatsoever case in any form of consultations. Those who were involved in consultations are people who were willing to withdraw from court cases or not talk about the evictions so that they could be allowed to talk to the bank. The process was such coercive that for those activists who insisted on talking to the bank, I mean talking to the authority, especially human rights defenders, they were arrested. And some of them are still facing charges, criminal charges related with their relationship with the land they are claiming from the authority. So there is nothing that should be stated that the affected people had any form of engagements or consultations. This simply implies that from the sources we have and from the information we have, we cannot talk about any form of consultations. What should have the bank done? Under normal circumstances, with such a very tainted track record, human rights record, there should have been a neutral party, a third party to help and conduct assessment, conduct due diligence to ensure that the challenges the authority is having with the local communities are detected well ahead of time. It has been documented all over that the Wildlife Authority in Uganda is having constant conflicts over land and use of natural resources in these areas. And letting this authority conduct its own due diligence process and conduct consultations is always going to become problematic. And I thought this is where we have a challenge. If the bank is going to finance an authority that is already in many years of conflict with the local communities and trusting it to conduct consultations, then there is never going to be any kind of genuine or trusted form of consultations. Because if communities have lost trust in the authority, there is no way they are going to accept or understand any form of explanation given. Thank you.
Thank you, Gerald. Anna, I'll turn to you next. Once the community started to raise their concerns about the gold mine, what do you think the bank should have done in an ideal scenario? What were you hoping their response would be in that case?
Well, first of all, I hope you're talking about the EBRD. EBRD received a complaint back in 2014 and did not actually process it appropriately. So the complaint mechanism was kind of aborted by the EBRD itself. It should have assessed. And just like, you know, the same claims were presented to the Ombudsman's Office of the of the World Bank of IFC, and that office actually did conduct an assessment, which of course, again, they found that, for example, the World Bank officers that were supposed to actually do an assessment did not actually visit the site, did not actually talk to the locals. They only consulted the client and the World Bank's local office here in the capital, Yerevan. At the same time, you know, the Ombudsman's Office did find in compliance with a number of IFC standards. The same same should have been done by EBRD back in the days when the first complaint was lodged. Well, that would have raised a lot of more problems to their potential participation, and they should not. Well, after 2014, they continued with a very large equity participation in the company, and they touted that this was for specifically the environmental risk mitigation program, and a very notoriously dangerous idea of so-called environmental offsetting. And I think that's another way of kind of misleading both the complainants, both us as people who are complaining against this project, but also the government and the larger international community, and also was trying to set a very dangerous precedent, the so-called environmental offsetting, because they promised money for destroying, they put money for destroying an important habitat, not to speak about the rest of the environmental impacts, but they promised that they will create some sort of a natural park, natural reserve. And those kind of things are very dangerous because they A, set precedent, B, they mislead, and they don't serve to the purpose, and C, eventually it was a risk for itself, the EBRD itself, because the complaints were not met with proper response. This anger, this rage actually increased, and eventually when people had the opportunity for freely expressing their will, which happened after the regime changed in Armenia, they did stop the project physically, and so EBRD lost in a way, and all of its share. All of the participants of the project. And to finish, I answered your question, but I want to make a remark on what Heidi was saying, and especially, the risks that environmental defenders and land defenders are facing. I want to raise a big red flag right here in front of all the listeners, and hopefully the financial institutions themselves, the World Bank itself. The mining strategy that is being drafted with the support of the World Bank is going to have detrimental impact on environmental defenders and land defenders, because it has such clauses in the draft already that there will be huge land collisions, huge problems and huge conflicts with landowners, with the farmers, with any other property owners, where mining will be commissioned by this government. So what I want to say is that right now we have a very specific already risk if a draft mining strategy is going to look like it looks right now in the hands of the consulting company commissioned by the World Bank or the government, doesn't matter, supported within that project. Thank you.
Thank you, Anna. Very worrying that the World Bank is so involved in this, given that IFC withdrew from the Amulsar project. Anita, I was hoping to go to you next. You mentioned earlier about the UN Working Group on Business and Human Rights guidance around engaging with and safeguarding the rights of human rights defenders through the UN guiding principles. Could you just expand a little bit on what you think development banks should be doing to prevent reprisals linked to their investments?
Yes, well, I think, again, this goes back to, and I think we've heard both from Gerald and Anna and then Heidi, just about it begins with engagement with defenders and with rights holders around understanding the nature of the impacts and the risks. And from there, and what we've heard is the failure often to even consult or to really properly anticipate what people need, rather substituting with sort of cursory due diligence. So that is the key. And then from there, I think it's also about anticipating then what are the heightened risks to defenders and others of reprisals. So I think this is going to be the challenge for everybody, is just how to use human rights due diligence properly. Secondly, it's about, as part of that human rights due diligence, having a focus on a particular heightened risk for defenders is of reprisals. and of use of legal proceedings against them. So having a strategy, and again, wearing blinders and the working group's guidance speaks about sort of concrete steps that development finance institutions or states, but can take to have policies and practices. Now, grievance mechanisms, and I'll just stop with this, is what's one of the things that's key and deficient. If you have a policy against reprisals, you need clear, safe channels that are widely known to defenders of how they can actually quickly communicate their concerns and their risks. And this, I think, is what we've seen has been a big gap in what's missing.
Thank you, Anita. And I think we've heard from a lot of speakers there, this intrinsic duality between engagement and reprisals, and it's also tied up together. We can't really separate those two issues. If we don't have proper channels for engagement, then we're not going to be able to tackle reprisals. And if we don't tackle reprisals, we can't engage well with human rights defenders. They're not going to want to speak out. So thank you very much for highlighting that. I'm just going to close now the panel with a final question for Heidi. As I mentioned, I wanted to come back to this new EU Corporate Sustainability Due Diligence Directive. I wanted to ask you, Heidi, what will be the impact of this legislation for development banks once it's finalised, and what are some of the challenges and opportunities that lie ahead? After all, we're still in the draft phase of this legislation.
Yeah, absolutely, you're right. There's been a growing interest among the European Parliament to participate in the drafting of the Parliament's position. And we are, I think, having now about 10 sectoral committees that want to have a say, which means that it will be a very complex exercise, maybe a bit more time consuming than we could afford. But the main thing is, of course, that there is great interest, but of course there are also contradicting views. I think the development banks will face more and more requirements, voluntary or statutory, obligatory, because of their clients, the projects and companies and entities that they finance, who are bound by this forthcoming legislation. So there will be an interesting, I would say, you can't call it spillover effect maybe, but it will come to the attention of the development banks that actually their clients have to follow the due diligence process and do it right. So I would say that this creates an interesting dynamics, I hope at least. As Anita said earlier, that there is the state responsibility to protect human rights. And when the private sector, indeed, according to the UN guiding principles, is obliged and has the responsibility to respect, then every organization, in one way or the other, belongs to one of these categories. So there is no escape anymore. I think when this idea has made a breakthrough that corporations and other organizations are indeed liable for what adverse impacts they cause or are complicit in or contribute to. So the issues we still have to I think work out in a constructive way are all related to being aligned with the UN guiding principles, because that's also something that the companies are saying, that we already know the guiding principles, we already know the successive OECD guidelines, so don't start to invent something new. And the key things that I'd like to mention here, which we need to sort of straighten out, are a proper mechanism on access to justice for victims in the area of civil liability primarily. Then I believe that we have to make sure that there is no sort of cascading of the responsibility on due diligence to suppliers and subsidiaries, but that it's all the parent company, the company that is using suppliers and other business relations must have the responsibility to make sure that the due diligence is there. You cannot, you should not outsource it. And now the mechanism in the EU Commission's proposal is a bit off track, I would say, because it talks about contractual relationships, contractual due diligence. So in a way, you could say it's outsourcing due diligence. So this we have to sort out. Well, there's a couple of other things, but I think there's also a little bit of an understanding among the European Commission that what they came up with in February as their proposal to the legislatures, the Parliament and the Member States, was a sort of political compromise. And I'm not saying that the political compromises would not happen in the European Parliament, but we may need to see that where these political compromises went off track. So a lot of work to be done, and I'm sure that a lot of interaction with many different stakeholders, including you. So I very much look forward to working with you and all the others which have already contributed massively to this situation where we are now, which is a positive situation. By the way, at 5 o'clock, I have to join the first meeting of members of the European Parliament who are involved in drafting the subcommittee on human rights opinion of this directive. And I think you will give me the permission to leave at 5 because it's for a good cause. So thank you very much.
Absolutely, and pleased to hear that that's going ahead. And a complex topic to sort of summarize there. So thank you, Heidi. I think important to say to all the civil society organizations and individuals on this call that there's really still scope to influence this legislation. So we should continue to follow and engage and push for some of those things you've raised there to be improved.
Hanna, can I make one proposal? Because I heard that there is this very worrying draft mining strategy of the World Bank. So I wonder if perhaps some of us could, Anna, perhaps we could write a letter to Kristalina Georgieva, the what's her title, President of the World, is it President? I think so. So indeed, I think it might be a good idea that I could perhaps, together with a few other members of the European Parliament, we could write a letter to Kristalina Georgieva. We know her from her previous job in the European Commission. She was the Commissioner for Humanitarian Action and Budgets successively. So if you can help me, I would be happy to do that. So please stay in touch. And yeah, thank you.
Oh, thank you. I definitely will be. Thank you so much.
This is what I like to see, some collaboration already coming out from this session. Thank you, Heidi. I think we've got time just for one quick question, and then I'll go to final comments. Heidi, if you have to drop off, no worries about that. We've had a couple of questions around private security firms and the retaliations against defenders that they've been enacting. So Anna, I was going to go to you, and any other panelist who wants to jump in, just let me know. How do you think we can pressure development banks to ensure that the clients they work with only contract responsible security providers, given that this is such a significant issue, particularly around the protests?
Yes, Hanna, that's a complicated question, quite honestly, because it seems somebody mentioned in the chat of this Zoom platform that there is some sort of a standard for security companies, which, development banks should probably require their clients to comply with. I'm not aware of these standards, but what I can say is that a lot of things, happen on a daily basis, when problems arise. And so the problems that we have seen so far have been very militarized and very brutal security companies who, for example, wear military uniforms, which they're not supposed to do. And in a country, a warring country, Armenia is in a state of war. Actually, wearing military uniforms is forbidden, but also raises a lot of triggers in the society, in the people, in the public. So, seeing, people wearing military uniforms and wearing guns, this is the most important thing. Security officers out in the field, protecting basically nothing, because there were blockades, and the local residents were able to have the company stop its operation, and everything was just quit in that area, and they were not allowing for new things to happen, like equipment to be moved to the scene, etc. These places, and especially with the history of peaceful protests, we don't need to see armed, militarized security forces brutally attacking protesters, disguised by so-called protecting property. There's not even any property there. It's just, there's not even a fence there. So what I want to say is that I don't know exactly how we can pressure, maybe, somebody who's more aware of these international standards on security companies, and these kind of things can mention them, but we should constantly be in communication and raise issues to development banks as they come. And already they should do an assessment of the reports that you have compiled, or I mean the coalition for Human Rights and Development has compiled, and all other reports, all other alerts should be taken into account to make sure that militarization and brutalization is prevented when they try to protect their properties or their assets or whatever it is. Because normally people who are fighting against these kind of notorious, harmful projects, they're peaceful protesters, and rightfully peaceful protest. They have the right to protest things that damage their lives. Thank you.
Thank you very much, Anna. And I think this is a trend we've seen in a number of cases. So it's something that we particularly need to focus on when we're looking at this issue of reprisals. I'm going now to go through the speakers and just ask for a final comment or a key takeaway from today's session. But Heidi, I'll be going to you first, but beforehand, I just wanted to say apologies, we didn't have a lot of time for Q&A. So Lorena has kindly put her email address in the chat. So if you have any follow-up questions, please feel free to reach out, and we'll be sure to get back to you with a bit more detail. So yeah, to final comments from our panelists. Heidi, over to you. Oh, is Heidi still here? No, Heidi's had to pop off. So Anita, can I go to you first?
Yeah, just very briefly to say, as we think about reprisals, I've already spoken about the importance of the guiding principles and looking at the recommendations in our guidance, but more importantly, the new report. The other piece I'll just say is that the World Bank and development finance institutions also have an important role in focusing on the judiciary and the legal systems of the countries they're in to prevent abusive legal process against offenders as well.
Gerald?
Thank you. From a community perspective, from the people who are facing these challenges, I think there is more need to continue building these kind of solidarity engagements, building these kind of movements and talking to banks, building kind of an advocacy force that would keep talking to the funders of these banks to make sure that they begin listening and understand the challenges local communities face when such projects are funded and nothing is followed up to ensure that these projects do not cause any harm on the local communities. And the other most important thing is that we should try and push and ensure that aspects related with reprisals are prevented as much as possible, and we must build a rallying force to make sure that we build a stronger voice to keep condemning reprisals. Thank you.
And last but not least, Anna.
Yes, thank you. My final remark will be something that maybe is related to one of the questions in the chat. The global situation is very demanding for a lot of people, but especially the activists and human rights defenders. And when I say global situation, I mean both the climate change, but also the wars that are raging around the globe now, which is so heartbreaking, because I am triggered myself being in a country which is seeing wars on and on. And this is very demanding on us, both physically and emotionally. So sometimes we have to stop doing what we are doing, for example, environmental protection and advocacy for conservation or advocacy for human rights of people that are affected by various dangerous projects, to literally saving our lives or literally saving other people's lives who are being affected by wars. I mean, we have the war raging now in Ukraine. Armenia is not detached from that kind of a reality. I mean, we just had 2 years ago a war. But what I want to say is that the global situation is so demanding. At least we should not have wars. At least there should be a peaceful, non-militarized, non-armed situations for us as activists to continue our fights in a peaceful manner. I mean, that's at least what I would dream of in this world. Because as it is, our fight is already very demanding. We are already facing so many dangers. I mean, facing a war on top of this is so unacceptable and so unimaginable. Thank you.
We're going to finish up here. I just wanted to let everyone know that the report is now live. It's available in English and a summary as well in French and Spanish. So the link to the report will be shared in the chat. And I just wanted to end by saying, you know, many of these development banks have made commitments to addressing reprisals. They have public statements. They have added these commitments to their environmental and social frameworks. And it's important that we continue to hold them accountable for those commitments and ensuring that they go beyond the statement and they start to put in place concrete action. So yeah, finally, just to thank everyone at the Defenders in Development campaign who's pulled this together. It's a really excellent report, and I do encourage you all to go away and read the report. And thank you to all of our speakers, to Anna, Gerald, Heidi and Anita. We very much appreciate you joining today and for sharing your stories. Thank you, everyone.